Hello and welcome back to another video on my channel. Today we're going to be taking a look at what the Supreme Court did when it came to Trump's ability to use the National Guard in Chicago. Now, as we already know, the majority, as shown on the screen here, found against Trump's ability to use the National Guard in Chicago, whereas the dissent obviously had its reservations or would have found oppositely. So, I'm going to first start with the majority, then we'll move to the dissent, and as always, it is not my goal to tell you what to think, merely give you information to think about when you are coming to your own conclusion. So here, I went ahead and I did a visual representation because I realized not that many people are familiar with the people on the Supreme Court and who they are. So I just want to get you familiar with these individuals. So Kagan, Jackson, Sotomayor, these are known as the liberal justices. This is Chief Justice Roberts here. Amy Coney Barrett and Brett Kavanaugh are Trump appointees. Kavanaugh is going to join in the majority here, but it is going to be through a concurrence where he expresses some reservations. But we're not going to go super deep into that because it's not as interesting as the big picture, and I want to be respectful of your time. So here's what the majority says. October 4th, President called 300 members of Illinois National Guard into active federal service, yada, yada, yada. Now, what happens is that the president is relying on 10 U.S.C. 12406, which empowers him to federalize members of the Guard if he is, quote, unable with the regular forces to execute the laws of the United States, end quote. Now, this language from 12406 is where the court is going to hang its hat and what this case is going to come down to. Here, the court then goes on to say, we directed the parties to file supplemental letter briefs on an issue that the district court had addressed, but the parties' initial briefs had not. The meaning of the term regular forces in 12406. Now, I underline that and italicize it for an important reason. This is going to come up in the dissent as to why the dissent takes issue with the Supreme Court telling them what they want arguments on that are different than the issues initially raised. So, the meaning of the term regular forces is what they're looking for. In its supplemental brief, the government argues that the term refers to civilian law enforcement officers, such as those employed by Immigration and Customs Enforcement or the Federal Protective Services, whereas Illinois is echoing the district court and maintaining that the term refers to the regular forces of the United States military. We conclude that the term regular forces likely refers to the regular forces of the United States military. This interpretation means that to call the Guard into active federal service under 12406, the president must be unable with regular military to execute the laws of the United States. They're drawing a distinction between regular military and the National Guard. Because the statute requires an assessment of the military's ability to execute the laws, it likely applies only where the military could legally execute the laws. So if the military couldn't act here, certainly the National Guard will not be able to act here either. Such circumstances are exceptional. Under the Posse Comitatus Act, the military is prohibited from executing the laws except in cases and under circumstances expressly authorized by the Constitution or an act of Congress, 18 U.S.C. 1385. And this is another thing that's going to be brought up by the dissent. They're going to say, well, isn't 12406 an act of Congress, and didn't you sort of invalidate it unnecessarily? But that should have been the act of Congress that allowed the president to do this. All right, returning to the court. So before the president can federalize the Guard under 12406, he likely must have statutory or constitutional authority to execute the laws with the regular military, and then he must be unable with those forces to perform that function. And then only after that would he be able to call in the National Guard, is what they're saying. One thing I didn't like about the majority's opinion is it's very short, but also they only cite to one case here, and that's going to be Azar Alina. This is a healthcare related case looking at the retroactive withdrawal of Medicare funds. And so it actually has nothing to do with what's going on here, but the reason why they cite it is for a principle of statutory interpretation. Here is the proposition they're citing it for. This court does not lightly assume that Congress silently attaches different meanings to the same term in the same or related statutes. Here they are using this to justify their interpretation of 12406 and squaring it with the Posse Comitatus Act. In the opinion, this is the only case. So that's kind of my issue with the majority from a jurisprudence, writing perspective, not actually a political perspective. Again, My opinion's not here. Doesn't matter. All right, so this is going to be the dissent. Justice Alito with Justice Thomas are going to join together, and Gorsuch is going to file his own dissent, although he is going to agree with much of Alito. Let's go ahead and get into that. Justice Alito and Thomas are going to, and this is not quoting the opinion, this is just going to be a synopsis. The dissent argues that the court has broken a basic rule by deciding the case based on an argument that neither side properly raised, whereas the court normally rules only on the arguments the parties present, not invent new ones. So again, the court is supposed to, in an adversarial system like ours, it is supposed to be the job of the lawyers to raise the arguments, not the judge. The judge decides the winner, but they do not step in and provide winning arguments, even when they see them. That's not their role. The court also went further than necessary by offering opinions on major legal questions that were not fully briefed or argued, and that increases the risk of error. The most important thing to know about this decision is that this is coming on the emergency docket, so we didn't have full briefing and we didn't have oral arguments. And so that gives some of these dissenters pause, and I think similarly with Kavanaugh's concurrence, he mentions this if I remember correctly. So the risk of error is going to be high. The dissent also objects that the court effectively rewrote the statute by adding a limitation that does not appear in the text that the Congress passed, and it criticizes the court for implying that the statute authorizing National Guard deployment may not count as an act of Congress under another federal law, a conclusion the dissent finds implausible. The dissent is concerned also that the court suggests the National Guard may enforce laws but may not perform basic protective duties such as defending federal officers or facilities, which the dissent sees this as illogical. So here what the majority was getting at is, yes, you could bring them in you could bring them in to enforce the laws, but the Trump admin's justification was protecting federal property and officers. That's not enforcing the laws. Here the dissent is going to point that out as being somewhat illogical. Finally, the dissent faults the court for failing to explain why the president's inherent constitutional authority to protect federal personnel and property would not independently justify the Guard's use, because as we know, the Constitution is greater than the acts of Congress. It will supersede them. It takes precedent over them in questions such as this. Here, I actually did appreciate there was more than one case cited by the dissenters. One of them is Martin versus Mott. There, a militia member argued, among other things, that the standard for calling up the militia under the law in force at the time had not been met. And they're going to look at the case and they're going to reiterate what the court said at this time back in 1827. So here the court asks the question, by whom is the exigency to be judged of and decided? Is the president the sole and exclusive judge whether the exigency has arisen, or is it to be considered as an open question? We are all of the opinion that the authority to decide whether the exigency has arisen belongs exclusively to the president, and that his decision is conclusive upon all other persons. So that is seemingly going to contradict what the majority is saying here, which is the president doesn't have the authority here, whereas back in 1827 they seemingly said otherwise. All right, we're not going to spend too much time on Gorsuch's dissent separate. I have done a little bit of a summary of the questions he raises, but the way he organizes it is he raises quite a few different questions that this case and this matter has brought before the court, but is not actually willing to take the time to answer properly. So he lists them all out. Then he goes on to say, in the present posture of this case, I am not comfortable venturing an answer to any of those questions. This court has never decided a case about the meaning of 12406, let alone explored its interaction with other statutes in the field or the Constitution. Nor do we have much help on many of these matters from the parties' briefs before us. Understandably, given this case comes to us in an interlocutory posture on a highly compressed schedule, that being the emergency docket. 12406 statutorily permits the president to call up and deploy the National Guard when he is unable to execute federal law with civilian federal law enforcement officials. Proceeding on that same premise, I believe the declarations federal law enforcement officials submitted below support the grant of stay for substantially the reasons given in parts 1A, B1, C, and D of Justice Alito's opinion. So there you have it, guys. That is going to be what the court did, the majority and the dissenters in this case of Trump versus Illinois on whether or not the National Guard could be deployed to Chicago. So I hope this was helpful. I hope you found it informative. And now when you're thinking about it and forming your own opinion, thinking for yourself, hopefully you have all the necessary information, or at least more than you started with. Have a good rest of your day and enjoy the upcoming New Year celebration.